Good evening and welcome to Be Informed. My name is Carl Buhariwala and I founded Be Informed to help people make good decisions. Today, we're looking at the topic of business operations and we are joined by Gillian Miranzi of Scanlan, Carroll Lawyers, who'll be speaking to us today about business resilience during uncertain times in Australia. So this is a topic with a few sort of legal aspects to it. So all information shared in today's session is general information only. And if you do have any specific queries about your personal circumstances or the circumstances of your company, please do engage with a professional. This session is being hosted in Australia and the contents of today's session pertains to Australian law and is current as of this month. So if you do wish to view this session from a country outside Australia, or you wish to review this session in the future, you may wish to consider its applicability. So today's session will run for about for an hour, comprising of 25 minutes of seminar, followed by Q&A. And if you do have a question that you would like to ask Gillian, you can just email us, send me the question through the chat function, and I'll relay that through to Gillian for her to answer. And Gillian's also prepared a one-page handout, which I'll share with registered participants by email. So those are the main formalities. And Gillian, I think we're now ready to start the seminar, so I'll hand over to you.
Perfect. Alrighty, thanks for that, Carl. So the topic that I'm doing, presenting on business resilience during uncertain times in Australia. So the current cost of living crisis in Melbourne has not only caused a financial strain on individuals and households alone, but on businesses as well. And my presentation, when I go into it, it might appear a little bit doom and gloom, but that's not at all the aim of it. The whole topic is to educate, particularly as business owners and directors as well. And it is a topic that needs to be addressed, particularly because businesses are going under almost daily at this rate. The topic, as Carl said, is very complex and there are many different avenues and points that stem from this, but I've decided to focus on what I deem to be the most main important points for a business owner. All right, so the first slide. Perfect. So what is insolvency? So there's the main two forms of insolvency are bankruptcy and corporate insolvency, and that's what I'll focus on during my presentation because they refer the most to directors or impact directors the most in companies. So bankruptcy is a regime under the Australian Bankruptcy Act for dealing with debts of an insolvent person. So an individual can declare themselves bankrupt or a court can declare an individual bankrupt after it is proven that they cannot pay their debts as well. So if an individual declares themselves bankrupt or is made bankrupt, it lasts for 3 years and 1 day. It stays on your credit report 2 years after your bankruptcy period ends, and it remains on the National Personal Insolvency Index permanently as well. Now, you do not have to wait until the bankruptcy period has ended, so you can end your bankruptcy at any time by making an offer to your trustee to repay your debts. And a trustee pretty much is someone that will be appointed, or a company that will be appointed to manage your financial affairs because you're in a position to do so. So they'll look at all your assets and see what they can sell or can recoup to pay back creditors. Whilst you are bankrupt, any money that you do receive, such as a gift from a family, inheritance, or even if you win the lottery, will actually be used to repay your debts. So it'll go to your trustee. In some circumstances, you need permission from your trustee to travel overseas. You are able to work and earn money, but some jobs might have restrictions on people who are bankrupt as well. You're able to run a business, but your business will need to include your full name and you need to let people know that you are, or you may need to let people know they are currently going under bankruptcy. And if you own a home or financially contribute towards a house, your share will go to your trustee, so it will actually be exposed. And your house can potentially be sold to pay back creditors and the debts that you owe. And if you have a mortgage as well and you fall behind in payments, then the bank may take the house and sell it. And this is actually a common occurrence. I know people think that this is a worst case scenario, but we had a client who was not paying his mortgage for more than 10 years actually, and the bank was actually very, very patient, and eventually they ended up repossessing it and selling it. So it does occur. In terms of corporate insolvency, so a company is insolvent when it is unable to pay its debts when they fall due and payable. Now, directors have the responsibility here because it is their role to ensure that the company does not trade while it is insolvent. And I'm going to come back and focus on a director's duties and how it is their responsibility to prevent insolvent trading as well in a bit more depth later on. Now, the three most common types of corporate insolvency are liquidation. So liquidation is a process which results in a company being pretty much shut down. All the company's assets are sold and the money is raised to repay its debts, the company's debts, and the creditors as well. You often hear the term winding up being used to explain this corporate insolvency. What's a very interesting aspect of liquidation is a clawback provision. So a lot of people find or think that, well, if a company goes under, they look at the directors and they've given away assets of the company or even personal assets, and that's it, nothing's under their name. So that's the end of it. But no, actually, there are what we call a clawback provision where liquidators who are appointed as the company can go in and look at assets that have been given away. And if they truly believe that that director gave away assets of the company to avoid paying creditors, it can be clawed back. This has happened twice. So one of our clients, for example, gave away really luxurious motor vehicles that were company assets. And the liquidator said, you either pay the value of the motor vehicle or we're clawing them back. You need to be able to get them and give us back. They were able to give back one and had to pay for one. So you need to be very careful when people think they're being, I guess, clever by defrauding creditors, by getting rid of everything and not putting anything under their name. Another really interesting one which shows the period of how the clawback works is I attended a seminar that was done by an insolvency practitioner. They explained a story where the liquidators were trying to claw back assets of a company that was given away 6 years before the company actually went into liquidation. And you'd think 6 years is a very, very long time ago, but they genuinely believed that the directors of that company gave away assets to defraud their creditors. The matter went through the courts, and unfortunately it was held that no, it was a genuine attempt to get rid of assets at that time, not to defraud creditors, but there's no time limit to it. So these liquidators ran a matter for 6 years prior to the assets being given away, which I thought was very, very interesting. Another common type of corporate insolvency is what we call voluntary administration. And the whole purpose of this is to rescue, if possible, the company that is in financial difficulty. So a voluntary administrator is appointed and they take control of the company and they manage its affairs until the creditors decide the company's fate. So if they try and see we can restructure the business in some way and we can pay some creditors, enter into payment plans, and the company can be saved, then that's absolutely the goal of a voluntary administration. If can't, then you go out through the liquidation route. Another common type of corporate insolvency is what we call receivership. So this is a process which entitles a secured creditor to appoint an insolvency practitioner as a receiver to the company. So their role is to take control of the secured assets to pay back secured debts. So for example, loan agreements most of the time gives right to a creditor to appoint a receiver under certain conditions. And a process that's quite recent, which it commenced in 2021, is called a small business restructuring. So the purpose of this process is to allow eligible businesses to comprise their debts with their creditors' agreement, and it allows for the business owners to remain in control of their business. So you don't have this outside third party coming in and managing the financial affairs of the business, and it's looking at restructuring as well. So it's a preventative measure and it's trying to save the company rather than focusing on just closing the company and shutting down. Now my next slide, talk about preventing insolvency. Perfect. So directors. So as I mentioned before, directors have a responsibility to ensure that the company does not trade while it is insolvent. This can lead to bankruptcy, particularly in circumstances where a director has provided a personal guarantee for business loans, which happens all the time. Very, very common thing to happen. So if a director is found guilty of insolvent trading, they could be subject to civil penalties, personal liability proceedings, and criminal charges as well. So a civil penalty can include a fine of up to $200,000. A personal liability, if you're held personally liable, that can result in bankruptcy. Proceedings can be brought against you by ASIC as well, a liquidator, or even a creditor. And then criminal charges include a fine of up to 2,000 penalty units, which is currently valued at $550,000. and or you can even face imprisonment of up to 5 years in very, very serious breaches. So the consequences of insolvent trading can cause a director to declare bankruptcy, as I've said, or if you're found guilty of a criminal offence, you may also be disqualified. And so disqualification prevents you from continuing to act as a director or manage any other company for a period of up to 5 years. And in very, very serious circumstances, I've had people be told they cannot act as a director anymore. Very serious breaches, though. A director penalty notice issued by the ATO. So another responsibility that directors have is to ensure that their company complies with all their tax and super obligations to avoid personal liability. So as a company director, they're responsible for ensuring that the company's tax and superannuation obligations are reported and paid on time. If the company doesn't pay these liabilities by the due date, the ATO can recover these amounts from you, I say you, but the directors personally as current, or even a former company director, or even a shadow director. So a shadow director is someone who is not legally or formally on the paperwork with ASIC appointed as a director, but they act in that role as a director as well, just maybe in the background or even forward as well. So you need to be really careful that people are not acting as shadow directors. Now, the director penalty notice itself outlines the unpaid amounts and options available to directors. So the ATO can recover the amounts of a director penalty notice by issuing a garnishee notice to the director. They can offset any of your tax credits against the director penalty notice, and they can even initiate legal recovery proceedings against the director. Once the ATO has given a director or director's penalty notice, they have 21 days to either pay the penalty amount in full. They can engage with the ATO and negotiate a payment plan for the debt, or they could provide a defense. Now, providing a defense is a bit of an interesting topic because there's some defenses that are acceptable and there's some that are just not acceptable and won't be accepted by the ATO. So examples of acceptable defenses are you didn't take part in the management of the company during that period where it's found to have breach because, for example, of a really serious illness. So you're actually away from business management or any other acceptable reason the ATO will be willing to consider. Another reason might be you took all reasonable steps to ensure that, the company tried to pay the outstanding amount, you appointed an administrator of the company or even a business restructuring practitioner. So you were trying to, rectify the breaches. Or you could even state that as the company began to wind up the company, so you took steps to appoint a liquidator and go down that path. It is not a defense, however, to say that as a director, you relied on someone else to ensure that the obligations was met. So either your fellow directors or even professional advisors. So a lot of people will say that's why I hire a bookkeeper or an accountant. They're supposed to tell me if, the company isn't paying the taxes and super, but that is not a valid excuse. As a director, the liability is with you at the end of the day. Also, a resigning director does not also remove your obligation or alleviate the penalty. So you may resign during the period of time and move on with your life. You can still be held personally liable. And the same as well applies for people that are buying a business with these debts and loans. So it's really important to get a legal practitioner to always look at the sale of business contract as well and carefully have an accountant look at the books as well. So you're fully aware of what you are buying into the business and any debts. And also a non-participation as well is not a valid defense. So you might have a lot of directors appointed in the company and it might be your responsibility to look after staffing, then your fellow is supposed to manage the books, and another director, whatever, has a different role as well. So it's not a defense to say you just simply did not know about it as well. It's not valid. So you will still be held personally liable. My next slide is about business contracts. So this kind of falls a little bit into preventing insolvency as well and protecting yourself as a director. And one of the main forms is having valid business contracts or a good structure of contracts in place to protect your business legitimate interest. So the first one I said is a shareholders agreement, and a shareholders agreement is a document that sets out the rules and processes which apply to the shareholders of a company, and it determines the rights and obligations of shareholders, as well as governs the relationship between directors and shareholders as well. Terms and conditions is a good document to have, and you should have it if you're providing services. And it's a legal contract that defines the rules and guidelines for using a product or a service as well. It establishes the rights and responsibilities of both the provider and the user. And then unfair contract terms. So I've included that as its own separate, I guess, category, because at the moment here in Victoria, we have an unfair contract regime, and the ACL, they're coming very hard on businesses that include unfair contract terms. So you have your shareholders agreements and you have your terms and conditions, and I've outlined those two because I think they're very, very important to have if you're running a business to protect yourself. But you need to be careful of other forms of contracts that might include unfair contract terms, whether you're signing up to one or whether you're the one preparing and providing it to other individuals or businesses. Some contracts that have been found to include an unfair contract term are insurance contracts, supply distribution agreements, and contractor and subcontractor agreements. They're the most common ones. And just for context, what an unfair contract term is most business will use a pre-written contract, and other business or persons unable to change any or majority of the terms of the contract, and it unfairly favors one party over the other as well. And if that favorment is held to not protect the legitimate business interests or the commercial aspect of the I guess relationship, then it's held to be an unfair contract term, and there's some very severe penalties that have been applied, and it keeps updating and changing to make it more severe as well. Another form of unfair contract term that people need to be careful of are restraint of trade clauses and termination clauses as well. So you might have someone that might leave the business, but that's their niche of area, or that's the area of career that they've always worked in, want to start their own business. That's not uncommon, and that happens all the time. You need to make sure your restraint of trade isn't too far-fetched. You might say, for example, you can't say that person can't work in Australia. They need to make a living as well. And termination as well is a very, very common one. And I'm going to come back to termination because obviously that comes down to staffing and employment contracts, which is another very important contract to have as well. So it's just important to remember with your business contracts that when you review them and you have a lawyer look at it, if it causes a significant imbalance in the parties' rights or obligations, and it's not necessary to protect your legitimate business interests, and it causes an unfair advantage, or would cause a financial detriment to another person, it probably is an unfair contract. Okay. And then my next slide. Thank you. Business disputes. So a lot of business disputes will arise from unfair contract terms as well. But then also as well, if you don't have really good contracts in place and they're not drafted properly by either a solicitor or, you just wrote on the back of a napkin, which has happened before, you are most likely to get a dispute. And it will arise from confidential information and in the taking of intellectual property as well. Unpaid debts, which falls back into what I was talking about before with insolvency and bankruptcy. That's one of the most common disputes. Contractual issues, restraint of trade, termination, those type, and the quality of goods and services, which are protected by the Australian consumer law as well. I'm going to focus on unpaid debts, debt recovery proceedings, because that's how most companies will probably go under. As I mentioned before, you don't pay your debts, then it's an act of insolvency as a company, and then that's when all those directors' duties will be brought to light as well. Next slide. Okay, so staffing arrangements. So obviously an employment contract is a must if you have staff that work under you. Some people don't have employment contracts or treat all their casuals and full-time workers the same, which I would not recommend, but you'll have to seek legal advice in regards to that. But the reason why I actually put in a social media policy and uniform policy there as well is because I want to give an example of how times are changing, and with businesses, you'll need to change with the times as well. Yes, there's the cost of living, but this is also the age of AI and technology. So we had a client who was an employer, and they had an incident at work, which is private and confidential. And then what happened is one of the employees posted about it on TikTok. And she didn't have a lot of followers, but it was enough to see that, the company could be recognized. It brought the business into disrepute. And it was an incident that happened at work, and it should have stayed at work as well. So luckily for them, they had a really good employment contract, and we also looked at their social media policy, which they had implemented as well. And that was actually reasons to let her go, which you have to be really careful as well as an employer if you want to let staff go, because obviously that impacts the business cash flow. and being sued as well. A uniform policy as well. It's a very random one for me to include there when it comes to staffing arrangement, but in this day and age as well, I had a client who didn't know what to do because one of her employees was dressing inappropriately to work, and who would have thought that, you think that was common sense. So we have to implement a uniform policy as well. So these three are really important: employment contract, social media, and uniform, to protect your business interests as well, your reputation, and also it protects you if anything was to occur, such as an unfair dismissal claim, an adverse action claim, an unlawful industrial action, or discrimination under the Fair Work Act. So protects you from your employees making those kind of claims as well. But at the end of the day, to protect your business interests, it's really important that you set realistic expectations and goals for your staff, that they are made aware, because you don't want to deal with debt repayments and insolvency proceedings, and then also be dealing with, a claim in the background for under Fair Work Act with your staff. So in a nutshell, that's my presentation today. I hope it wasn't all too scary, and a lot of people learn how to better protect themselves, particularly more contracts wise when it comes during this time with the rising cost of living. Thank you, Carl.
Thank you, Gillian. So Gillian's details are on screen. If you do have any specific queries about your circumstances or the circumstances of your company or business, please do contact Gillian directly, and she can assist. Today's session is being recorded, so if you have joined late, you can watch the entire session on our YouTube channel. And Gillian has kindly prepared a one-page handout, which I'll share with registered participants by email following today's session. So we'll now move on to Q&A. And Gillian, I guess one question that we've got, I think it'll be a great one to start off with, is in your experience, with the clients that you've dealt with, what are some of the common, I guess, triggers or, lead indicators, I guess, of when a business might be entering into tough times, and what can business owners look out for?
Definitely. The best form is obviously to take preventative measures, because once it's too late, it's really, really difficult to come back from and rescue, I guess, the business, to put it in kind words. Triggers for a director, as I said, is not enough to just hire bookkeepers and accountants. You need to stay on top of that work as well. So looking at your cash flow, looking at your employees' pay, entitlements, always regularly staying up for it. And the best practices that you have are directors that are very, very involved. There's not one right way or wrong way, I guess you can do it. But what I found is directors that catch on to it early are more likely to be able to save their business and engage in the right practitioners to assist them with their cash flow as well in that circumstances. So once most people like to come to see a legal practitioner or even an insolvency practitioner once it's too late and they're getting letters of demand for repayment of debt and they can't afford it. At that point, like I said, it's quite hard, and there might be interest repayments, that you have to make as well, and the ATO might be at your door. So it's really important you catch on to it early and regularly speak with your accountant or bookkeeper and check in on how the company is going. Don't just assume.
You're right. I think that's really interesting that you mentioned sort of cash flow, because I think that is important, right? I think a lot of businesses tend to focus on how much revenue they've generated and what their profits are, but that as most would know, and I'm hoping most business owners would appreciate, that doesn't directly mean that cash flow is also positive, right? And that's often I think it's a common underlying cause for many businesses to face these circumstances. And I think, Gillian, the next question that we've got is sort of around small business conduct. There is post-COVID as well. I think we can all appreciate there's been a rise in businesses having to close up or enter insolvency for various reasons. How, in your experience with clients that you've dealt with, sort of what were some of the good qualities that some of your clients demonstrated, I guess? What can you share with our audience today around demonstrating good behaviours? I know you mentioned a few already. By being active and checking the books and asking the right questions and all that sort of stuff. So, are there any others that you can share as sort of directors demonstrating the best qualities or good qualities when they are entering these tough times?
Absolutely. That's a very good question about what the best qualities are. Obviously, they'll come through and change from director to director. And I guess the best way I can answer that is just to share a case study of someone that I've gone through. And so one of my clients, their company went under and there was a liquidator appointed. And we acted for the director personally in this. And they had to, obviously, they sold off some assets and it was clawed back. Now, there was two directors of this company and their attitudes were very, very different. So one director said, we've done nothing wrong. I had other debts that I had to pay, absolutely nothing going on. And, they weren't approachable and weren't willing to help out the liquidators. And the other director was more forthcoming, wanted to really resolve the issue and help, save the company and everything as well. So I guess if you want to look at it from a perspective, I think being difficult, you can't run away from it, unfortunately. Once you receive whether a director penalty notice or you have a liquidator appointed, and that's what I say is the worst case scenario because you've been running from it. So these people have been appointed externally. But I guess going back to my point, if you act on it early yourself, enter into voluntary administration or even just the small business restructuring that's quite new, that's there to help protect and prevent businesses to go under. So definitely making use of all avenues available to you offered by the government as well, and engaging in, I guess, insolvency practitioners that can assist in your business. It's really bad to just sit there and ignore it. A director's penalty notice, do not ignore it. They're very, very serious and there's serious consequences about if you ignore it. The bankruptcy period also is not a time to start again, having this 3 years. After that, I'll just go and buy a new home. I'll do this. It's like I said, it stays on your the National Personal Insolvency Index permanently as well. And there's some very serious consequences that can come with that too. Like if someone in your family dies and you're set to inherit an inheritance, it can be taken. So there's no get away or just run from it and the problem will go away. It's something that definitely has to be dealt with. So that's how I would say the best approach, get someone that is proactive and engages with legal practitioners, accountants, insolvency practitioners, and just faces it head on.
No, thank you. Gillian, I've got a question from a consumer perspective. I think it's not uncommon, to read the news every now and again, and you see, companies are going under, consumers are being left behind, and what rights and, access opportunities they have, of course, will vary. But I want to flip it first on its head, Gillian, from a business perspective, I guess, to remind our audience sort of how critical is it to remember at the end of the day that, you still have customers or, I'm assuming most people want to continue on their business, but for the event. How important is it to maintain that sort of trust with your customers as a business owner when you're entering these circumstances? And, how is it important to communicate with your customers about what you're going through? Of course, not into the level of detail that they would be privy to, of course, but just to sort of keep that transparent line of communication open so that customers are not kept in the dark. Is that important in your opinion?
Absolutely, because at the end of the day, so if you're not quite honest with your customers or clients and they find out that the business might be going under, the first thing that it does is it causes panic, particularly if you have long-serving clients or customers as well. I think it's important, for your business's reputation and as a director to appear to be very transparent and working to resolve all issues and addressing all your clients' or customers' concerns as well. And also it protects your business reputation as well. So you don't want to be quiet and then your customers or clients hear on the news that this business has gone under, if they've gone to visit and there's a closed sign on the door saying it's permanently closed. That word of mouth sometimes is very, very powerful. Same with obviously social media with how your business is ran. So I would recommend as a business owner, if you are going through tough times, obviously if you've appointed a voluntary administrator, a small business receivership, and you are having cash flow issues, it will impact. And it's good to let clients informed, not involved. And you don't have to go out and say, oh, we can't pay our debts, we're going under. You don't have to be that transparent. But I think definitely for your long-standing clients, I think it's important to let them know that if there is a chance of the company going under, at least to make them aware. And I think it will keep your customer engagement in that aspect, whereas directors or shareholders, they just keep quiet about the company. They tend up to be in hot water, and you have a long list of creditors and bad reviews as well. So,
And what I'll do, Gillian, is to the individual that asked that question from a consumer perspective, we have had sessions in the past hosted by Be Informed about consumer law rights, what you can do if you do have a dispute with the business, and similar sort of topics. So if you want, I'll just direct that person to sort of maybe review those past sessions on our YouTube channel. I prefer to keep this session sort of business orientated. And what I'll do, Gillian, I'll jump to another question, which is a similar vein, but your thoughts, Gillian, on managing your relationships as a business owner with your suppliers and partners. So of course, if you are, running your business and you outsource a few aspects of it, and you do start entering into insolvency territory, what are the sort of key implications for a business owner to look out for? I know you mentioned in your seminar the importance of having, good contracts. Are there any others, Gillian, that you want to touch on to help business owners maintain that relationship with their suppliers and partners?
Yeah. And you're correct. It kind of flows onto the previous question about being transparent. Obviously, if you want to keep that business relationship going, if you have a contract, and I guess the most important one for that specific reason would be a distribution or supply agreement. It will outline what exactly is to occur if a business was to go under. So depending on the terms. So sometimes it might be all the services stop. It could be, depending on the period of time that the last goods is delivered on this date and then it's paid out and the relationship ends, or, if a receiver is appointed, they can continue. It will completely outline that and there won't be any ambiguity. If people don't have an agreement in place or a contract in place, that's when it can become a little bit murky, particularly, as I said, you'll have external people come in and manage the financial affairs of your company. And one of the things you need to be careful about clawing back. So you might have what we call priority creditors. So you might have a bank loan, for example, but then you have to pay this invoice of $1,000 to this person. You've paid it, but the company was insolvent at that time. That funds could actually be clawed back to pay back, for example, a bank loan. So that's an example. So you need to be very, very careful with the trade in insolvent provisions as well. And what I'd recommend is always have an agreement in place to protect yourself as a director and the legitimate your business. Yeah.
Yes, no, that's very wise, Gillian. I think just taking another question that we've got on this topic, we talk about business resilience, right? And I think to the person that's asked this question, which I'll explain in just a second, of course, this is a very legal sort of focused seminar. Of course, any sort of separate business finance, business tax advice, you would have to seek your own independent advice from those professionals. Gillian, the question here is more about how to sort of, plan for these events to occur, right? So, I guess from an emerging risk perspective, most organizations, large ones would have a well-established risk function, but for smaller businesses, you might not pay too much attention to maybe your current risk landscape, let alone your emerging risk landscape. I guess, Gillian, in your experience with the clients that you've worked with, how have you seen the importance of proactive risk management help not sort out, but more so, raise awareness of risks that could potentially lead to companies or businesses facing these circumstances. Do you have anything to share on that?
Yeah, absolutely. So proactive risk management is the best form, and I would say, in my personal view or experience, I would say most businesses, about 75 to 80% are saved with proactive measures in place. It sort of goes back to what I was saying, but it really, really is important that, business contracts are reviewed regularly as well. Same with employment contracts. That's a very proactive measure that you can take. Many people, as I said, use a pro forma contract. So we used this in 2012. It's always worked, and we'll keep using the same one. And it might have an unfair contract term in it. It might not be applicable to the person you're applying it to, then you might find yourself in a bit of hot water. So that's one preventative measure I guess you could take, is reviewing contracts. Cannot stress enough that you need to be involved in how the company is run. You cannot be a director and step back. You also don't want to be a shadow director of any company as well. So it's my friend's company and I just help out, and when they're on leave, I take over. That's also opening you up to risk as well. Engaging with other professionals, accountants, bookkeepers, legal providers, just taking any preventative measure that you can quite early as well. Creditors as well, reaching out to creditors and offering payment plans if need be. If you know that you might not be able to pay this lump sum now, liaising with them in faith, and that's also really good. It makes your business look good as well, and it makes you look like a director that's quite involved and knows what's happening. So that's what my advice would be.
Mm-hmm. Very, very, very important. And Gillian, I guess just on the topic of risk management, we're talking about here being proactive and taking sort of preventative measures. I think any business owner would agree that that's important. I think oftentimes, as you're stuck in the business as usual, the BAU sort of activities day to day, they become entrenched in that type of routine. Oftentimes leaving you to think about, just stepping back, from the balcony, so to speak, and just looking at your business and thinking about, where should I be improving things or taking preventative steps, etc. It is tough for business owners, right?
And it's easy. Sorry to interrupt you, Carl, but just to add on to what you're saying, it's very easy to let it slip through the cracks. Like you're saying, it's very easy for me to say that, manage your books, be on top of your contracts, but realistically, how many directors have time to do that? And that's why you engage your bookkeepers and accountants to do those jobs for you, and you trust that they, will keep you informed if anything happens. But unfortunately, that's not always what happens. Yeah.
Gillian, we've had a question which I'm just gonna flip it a bit, which is around, I guess, I think it goes without saying, there's always continuous improvement with businesses, right? Business owners should be continuously learning, on various topics, right, when running a business. Do you know, based on your experience working with your clients, are there any industry bodies or, associations that do support, the businesses they represent, I guess, when businesses are facing tough times? Are you familiar with it? I'm sure they exist, but does any come top of your mind just based on your experience?
The most recent one that I can actually think of is if you contact, I don't know, it sounds weird, it's an Australian government body, the Australian Financial Security Authority. They're actually really good in supporting businesses in that space, because I understand your business, you currently don't have debts. I think to engage a legal practitioner, they're obviously going to charge more. So sometimes you just need a little bit of that support and services as well. So that's one service that's really good. Insolvency practitioners probably know just a little bit more on that front, so I have to apologize, but that's one that I came into contact with quite recently, that one of my clients had used support and services, so they're good, and you just reach out to them.
Yeah. Without having done any direct research to the person that asked the question, I'm sure it does exist. There's the Victorian Chamber of Commerce. There's all these sort of larger bodies as well that that are established for this not for this direct purpose, but for supporting businesses. And I think it's important that the government does sort of, focus on small business support, given how small our economy is relative to others. And small businesses sort of do play an important part in keeping the economy going, right? So I know there are resources available through, various government streams. Gillian, we've got a very specific question, but I think it's worthwhile asking you the question. If a liquidator is appointed, do they act in the best interests of the business, company, or the individuals they represent?
Yep. If a liquidator is appointed, they act in the best interest of the creditors of the company. So a liquidator's role is to come in, look at the company's assets and financial affairs, and see where they can get money to pay back the company's debts. So in the end, if the company can repay its debts and it's all well, it might look good. But most of the time when a liquidator is appointed, that means the company itself is facing wind up, then cannot pay their debts as well. So a liquidator's main role is to ensure that the creditors get, they maximize the most amount of money they can get from the assets of the business for creditors' purposes. And a liquidators, for example, they can come up to directors personally as well if they find that you have breached your director's duties. And so they're not very kind once you reach that point. That's why it's really important to take preventative measures, because that's when they'll come back and they'll start clawing back. So like I said, that case where a person gave away a house that was a business asset, or I think it was a factory, 6 years prior, the liquidators try to get that back so that they can pay off creditors. So their interest lies with the creditors and protecting them. And they prepare reports as well, updating creditors regularly or when they find is necessary about how their investigations are going and where certain money has gone as well.
Right. And just an extension of that question, the person has asked Gillian, who pays the liquidator? So how is the liquidator sort of engaged and reimbursed? Just if you can just share a quick note on that.
Yeah, liquidators are paid at the end from the company itself. So they usually get paid first. So what happens is when a liquidator is appointed, they'll set out all their fees to the creditors, and the creditors will then vote. And if they're happy with the remuneration provided by the liquidators, it will proceed on that basis. So they will really try to extract funds as much as possible. A lot of insolvency practitioners who are liquidators, have acted as liquidators, have not been paid for some jobs. It can happen. And they usually won't take on, businesses like that to try and put them on. They might just put them under but not seek any assets payment. So it does happen, but they get paid by the company. Yeah. From funds, and they get paid first.
Out of the distribution, yeah.
Yes, correct, out of distribution.
Distribution, yeah. Okay, cool. Well, that I think, just checking there's no other further questions. That sort of brings us, I guess, to the end of our Q&A. So thank you, Gillian, for that. I'll just share the details again on screen. And, we're just chatting before we started. Just a quick congratulations to Gillian. She's become partner at Scanlan Carroll as well. So definitely achieved a great milestone in her career at the company, which is great. Gillian's previously presented on Be Informed as well in the past. So if you want to review some of those past sessions, you can head over to our YouTube channel, which is on screen there. The handle is there. So thank you all for joining. Just a quick reminder that we have recorded the session. So if you joined late, you can watch the entire session on today's on our YouTube channel moving forward. And Gillian has also kindly prepared a one-page handout, and I'll email that to registered participants. So you have that copy handy for yourself, and you can share it with family, friends, business owners, colleagues, whoever you like. So if you have enjoyed today's session, please do recommend us to your, family, friends, or your networks. Our social media sort of channels are on screen. We greatly appreciate Gillian and all the other presenters over the past 3 years who have dedicated the time to present. So thank you, Gillian, personally from me. It's been great to have you on board.
Thank you, Carl.
I hope those that have joined today or in the future will get something useful out of today's session. So that brings us to an end, and I'll wrap it up. Thank you, Gillian, and thank you all for today.
Thanks.
Okay, bye for now.